Graham Allen.
Mr Cosby, if I can be helpful to you and say that I will be requesting a vote on new Clause 5 relating to the protection of the Human Rights Act in the Scottish context when the due moment comes sometime after 10 o'clock.
The question is noted. Secretary of State, David Mundell.
Mr Cosby, thank you. I'm happy to respond to the points that have been made, and just to restate, as I did in the previous grouping, that I will be meeting with the Scottish Parliament Devolved Powers Committee next week, and that will be an opportunity to explore some of the issues that they have raised in their report. The starting point for the Government's position is that the Smith Commission's intention was not that the current constitutional position should be changed. Instead, the Smith Commission's intention was that legislation should accurately reflect political understanding of the Convention, and that is exactly what I see the clause as doing. What happens currently is that the Government does not normally legislate in devolved areas without the consent of the Scottish Parliament. As a result, the bill sets out, at Clause 2, that very practice. In doing so, it puts on a statutory footing a convention which has been consistently adhered to by successive United Kingdom governments. I understand the desire to put beyond doubt that we will seek the consent of the Scottish Parliament legislating on devolved matters. However, in effect, this proposed amendment seeks to limit the sovereignty of this Parliament by removing the word normally to state that the Parliament of the United Kingdom cannot legislate with regard to devolved matters without the consent of the Scottish Parliament. In reality, such an amendment directly contradicts Section 28(7) of the Scotland Act 1998, which states that Section 28 of that Act, which relates to acts of the Scottish Parliament, does not affect the Parliament of the power of the United Kingdom to make laws for Scotland. Indeed, this amendment would radically alter the way in which the practice was intended to operate, as envisaged by Lord Sewell himself.
I'm grateful to the Secretary of State for giving way. He's making a compelling case for the codification of these matters. I would say to him, however, that in fact the House has already on a number of occasions in different ways limited its own sovereignty, in particular in relation to the 1970 European Communities Act, and indeed there's judicial authority in that, as I recall. It's a factor time case. But surely he accepts that the mere act of putting a convention on a statutory footing is in itself a change, and for that reason the adherence to the word normally is not really appropriate.
It was not a change, though, to the way in which things are normally done. It was a change in the way in which they are set out and are on the face of legislation. It was quite clear that people, as part of the Smith process, wanted to see the Convention set out on the face of this new Scotland Bill, but I don't accept that they wanted to see a change to the Convention as envisaged by Lord Sewell himself. It's a fundamental principle. Indeed.
I thank the Secretary of State for giving way, but surely not even the Smith Commission wanted mere commentary to be dressed up as a clause, when that's all it is, mere commentary. There is no binding, cogent, constitutional bit of governance in the clause as it stands.
Mr Crosby, I've answered questions, obviously, from the Honourable Gentleman when he was part of the Constitutional and Political Reform Committee, and I understand the strength of his views in relation to these matters, but it was the view of the Smith Commission that the Convention should be set out in a bill of this type, and that's what the UK Government are doing. It's a fundamental principle of United Kingdom constitutional law that the United Kingdom Parliament is a sovereign legislature, and the people of Scotland voted last September to remain part of that United Kingdom. Therefore, it's right that this Parliament, while respecting the Scottish Parliament and their right to legislate, continues to be able to legislate for all matters without restriction on its sovereignty. Furthermore, I believe the amendment is unnecessary. The bill as currently drafted adopts the language which formed the basis of the Sewell Convention. When Lord Sewell said that he would expect a convention to be established that Westminster would not normally legislate with regard to devolved matters in Scotland without the consent of the Scottish Parliament, he did not intend his words to carry a technical meaning. The same expectation exists here. The wording used in Clause 2 will make its ordinary English language meaning. The Smith Commission recommended that the Sewell Convention be put on a statutory footing, no more, no less. That is what the bill seeks to achieve. To accept this amendment would be to go further than was recommended, would radically alter how the Convention was intended to operate, and would attempt to limit the authority of the UK Parliament. It is for these reasons that I will urge members to resist the amendment. Amendments 41 and 45 seek to make additional stipulations to the Sewell Convention. Let me reiterate that the bill already establishes that this Parliament will not normally legislate with regard to devolved matters without the consent of the Scottish Parliament. That convention operates effectively at present, and this amendment would appear to add unnecessary levels of bureaucracy to the procedure. I do not believe that the statutory requirements placed on members of this Parliament proposed by this amendment add any value to a process which operates well and is now being placed on a statutory footing by this bill. In relation to Amendments 19 and 20 and new Clause 10, as I've said, the bill, as currently drafted, adopts the language which formed the basis of the Sewell Convention. When Lord Sewell said that he would expect a convention to be established that Westminster would not normally legislate with regard to devolved matters without the consent of the Scottish Parliament, as I said in relation to my previous remarks, he did not intend those words to carry a technical meaning. We've established that the bill clearly states that this Parliament would not normally legislate with regard to devolved matters without the consent of the Scottish Parliament, and that is what the well-established Sewell Convention does and has been consistently adhered to by successive UK governments. We've had over 15 years of good practice in relation to the Convention, and it has not been breached. I don't accept, in the context of the remarks I made earlier, that it could be, and I believe that current good practice will continue. Obviously, the honourable member for Nottingham North has made reference to the government's plan to reform the Human Rights Act and its incompatibility with the devolution settlements as he sees it. Amendment number 5 in his name would make it more difficult for the UK Parliament to repeal the Human Rights Act. Let me be clear, Mr Crosbie, in relation to the government's intentions in this area. The government is committed to human rights and has pledged to bring forward proposals for a Bill of Rights. Protection of human rights is vital in a modern and democratic society, and this government will be as committed to any as any to upholding those human rights. The purpose of a Bill of Rights is not the diminution of rights. Its purpose is to reform and modernise our system and restore credibility to the legal framework of human rights. The government knows that its proposals for reform are likely to be significant. As such, it will consult widely on the reforms. Of course, we are aware of the potential devolution implications of that reform and will engage with the devolved administrations as we develop proposals. The government is currently developing its proposals, and it wouldn't be sensible to prejudge that process at this stage through this amendment. And I hope the honourable member will reconsider his statement that he wishes to move it. I think, Mr Crosbie, that I have touched on all the proposed amendments. As I've indicated, the Government is not persuaded by them at this stage, but as I've indicated, I will be discussing with the Scottish Parliament Devolved Powers Committee their report when I meet them next week.
Wayne David.
Thank you, Mr. Crosbie. We will not be pressing our amendments to a vote, but I do take note that the Secretary of State has said that he is not convinced, quote, at this stage, unquote. So I take that to mean that he is open to persuasion and to listening and hopefully being persuaded by arguments which will be put to him by members in the other place and indeed the Scottish Parliament when he visits shortly. Could I say there's something of a mismatch here between theory and practice, because theory has it, of course, that this Parliament is absolutely sovereign, but in practice, the very existence of devolution puts constraints on that sovereignty, and the very fact that we are members of the European Union also puts strains on that sovereignty as well. And I think that he's come to a point where that needs to be legally recognised. And there's no doubt about it. But the word normally is legally imprecise, and if ever it were a court of law, there'd be enormous difficulties about that. There'd be a conflict between the theory and the practice. So with those few comments, I very much do, as I said at the start, take on board what the Secretary of State has said, and I very much hope indeed that there will be movement.
Is it your pleasure that the amendment be withdrawn? Amendment by Leigh withdrawn. The question is that Clause 2 stand part of the bill. As many of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it.